Supplementary causeless, item number 1.
Where's the lawyers for the petitioner? No one's appearing. Yes. Why is no one on board?
Conducting counsel Shreya Shingha.
Where is she? Yes. Yes.
Your Lordship, this is an appeal. This is actually a civil revision against the maintenance order.
Against the?
Against the maintenance order, interim maintenance order under section 24 of the Hindu Marriage Act.
Okay. This matter had come before, right? Here.
Yes, Your Lordship.
What happened last time?
The applicability of the Family Courts Act. Your Lordship had, by way of order dated 10th of March, held that the Family Courts are the Family Court Act is not applicable to the state of Meghalaya.
Yeah. Oh yes. Yeah. Okay. Tell me.
On that order is also annexed herein.
No. I mean. Yes. Come to your present petition.
Yes.
Yes.
The present petition, Your Lordship. Now there is also a miscellaneous case seeking a stay of the operation of the order as well.
Where's the order? Okay.
Your order is at page 35. It is the 18th of July 2022. The operative part, Your Lordship, may come.
Page
35, Your Lordship.
Yes.
And the operative part, Your Lordship may come to, is para 27 at page 42.
Yes. Yes.
Considering the facts and circumstances of the case, the opposite party is hereby directed to pay maintenance pendentility at the rate of 65,000 per month with effect from the date of filing of this instant petition, and also to pay 60,000 as expenses, legal expenses. Now, Your Lordship, this has been paid up to date. First, all the maintenance payments, they are being paid at protest and without prejudice.
Right.
Your Lordship may see that there are two aspects. One, that the wife.
We'll do one thing, MS Singhal. Since this order of 18/7/22, we will issue notice on the merciless prayer also. You take steps and we'll hear it on the interim prayer the next date. Okay?
Very well.
Yes,
Would Your Lordship consider giving a date in July only because, in Delhi, the
we are
summer
on vacations. No problem. Yes. Yes, sir. MS S Singhal with MS S Salu for the petitioner. Issue notice. Returnable in July. No. In 6 weeks. 6 weeks will do? 6 weeks will be July.
13.
6 weeks from 13 July. Returnable in 6 weeks. Steps to be taken, price at 80 within 3 days. Stop. A list accordingly on which date in July do you want? Convenient date for you in July?
Yes, Your Lordship. Would Your Lordship consider 14th of July?
Yes, list on 14th of July. Yes. Now in the miss case number 8. This is an application for stay of the order dated 18/7/2022, passed by the Additional District Judge East Khas Hills in miss case number 42(H) of 2021 in MAT divorce suit number 12(H) of 2021 on the penalty maintenance amount allowed by the said order. Stop. Issue notice on interim prayer. The matter shall be taken up consideration on the next date. You ensure service is effective, then we can dispose it off on the next date itself. Yes,
Very well. Yes, Your Lordship, I'll come.
Yes, list accordingly on so and so.
I'll be there physically present also.
Very
on the
good.
14th. Deeply obliged.
Item number 2.
Before any other bench allowed me. Yeah. Clients before, right?
So today SRGT matter is already listed before the court, my lord. So if it can go, already the main writ petition is going on, is taken.
But the thing is that I'm not the roster manager.
Item number 3.
Who's there for the petitioner? Yes, Dr. Saraf.
One of the matter relates to a transport subsidy.
Yes.
One of the, by a circular which you'll also find at page 38,
Yes.
a relevant part at page 39, paragraph number 3.
38.
39
Para two.
relevant.
Internal
Para three.
audit. Yes.
Para 39, at page 39, para 3,
Right. Yes.
In view of that, it is clarified that as per the provision of the transport subsidy scheme 1971, subsidy is not admissible for the transportation cost incurred for interstate movement of the finished goods within northeastern states beyond the railway station nearest to the final destination. Therefore, transport subsidy for interstate movement of the finished goods within the NER is to be restricted up to the railway station nearest to the port of delivery. Now, this was circular issued by the Government of India,
Yes.
Subsequently, at page 40, the state clarification was withdrawn. You will also see para 2,
Yeah.
The matter has since been examined. This department, in consultation with the Integrated Finance Wing and the Office of the Chief Controller of the Accounts, after careful examination, it has been claimed that in the case of interstate movement of finished goods within NER, the cost of transportation beyond the railway station nearest to the railway point where finished goods is being transported is also to be taken into account for in the transport subsidy scheme. So, the earlier circular, which was there, you'll also see para 4,
Yes.
Para 4, according to the department's earlier letter, event number dated so stands withdrawn.
Right.
Now, thereafter, the petitioner, prior to that also, gave a letter about the short payment of the transport subsidy by various communications. And the department, the Director of Commerce and Industry, at page 47, you also see.
Yes.
Director of Commerce and Industry, wrote a letter to the Under Secretary Government of India. With reference to the above, I am to inform that the response to letter dated so-and-so has been furnished by department letter number so-and-so, copy of which is enclosed herewith. However, further response from your department is awaited. It is therefore requested to expedite furnishing of response to enable the department to take necessary further action. This was in the year 2019,
So the issue is still alive because you are referring to these are the periods. So which periods are you referring? Are you claiming transport subsidy? Is it
the period I'm referring to the letter, you'll also find it page 42.
Right.
This is 2011 to
11 to 13 only.
13.
Yes. 11 to 13.
Now, at present, what is the issue for that the department, Commerce Department, Government of Meghalaya, is regularly reminding the Government of India to give the clarification which is sought for, but the clarification has not been given by the department. You will also find the last letter at page 51.
Yes. Yes.
It says, kindly refer to the department letter number so-and-so, copies of which are referred. In this card, I have to inform you that response to the Government of India is awaited. It is therefore requested to expedite the furnishing of the response sought for to enable this department to take further action. Now, this was sent in 21. Thereafter, I gave a reminder, but since the matter is pending with the Government of India, the disbursement is not being done. So, at this stage, my prayer will be there before lordship that without going to into other things. Well, the Government of India is maybe directed to give the clarification within the time framework.
Will issue notice?
My lord, one submission, my lord. Kindly see the prayer, my lord.
Because the claim looks clear anyway.
Prayer is, my lord, that they are seeking to set aside the order of 1st November 2021 to 31st March 2023, my lord.
Where is that?
Your lordship will find at page 24. Yes, page 24. and the at 1/11/2011 to 31st.
That was source
This is the
sanctioning.
period for which the writ petition has been issued, my lord, after 10 years, my lord. And the ground which is being taken is that the matter is being reminded again and again by a lordship will see. Page 40. Page 40.
40.
40. This clarification was also issued, my lord. And page 41. Paragraph 5, my lord. It has also been decided that claims which have already been settled need not be reconsidered and reopened.
No, but the contentions that these claims were never considered.
Your lordship, because the payment was made between 2011 to 2013.
Payment has been made.
The case of the petitioner is that it is a short payment. It was not
because a case of short, not a case of non-payment.
No, it's a case of short payment, my lord.
Is that correct, Dr. Saraf?
Your lordship will see
that. Is it a case of short payment or the case of non-payment?
Your lordship will see.
If he has completed,
is it a case of non-payment or case of short payment?
The payment which was the earlier circular said that this payment should not be made. That has not been made. As per the circular, whatever the circular earlier provided, that this part of the transport subsidy should not be eligible. That part was not clear to the make payment to us. Now the circular was withdrawn, and thereafter again regularly we are giving reminders that kindly make the payment. My learned friend is referring to page 41. Now that says, my lord, by that you'll also find the letter was again and again written by the government of Meghalaya Commerce Industry Department that whatever clarification was sought from the government of India, that should be given, because whether the petitioner is entitled to or not on the basis of this. Now, unless and until the clarification comes, how the petitioner can challenge the payment of the now you'll also my learned friend is saying, you'll also see what I have challenged. I have challenged the quashing of the letter number so-and-so issued by so-and-so, short sanctioning the claim of the petitioner. I am not quashing.
Issue, my lord, issue is very short one. My lord, the basis of the claim is 2013 circular, which was as per the submission of learned senior counsel that it was modified. The same modification circular says that the already settled case will not be resettled. Kindly see page 42, my lord. Page 42, my lord. Page 42, your lordship will notice that amount claimed for, amount sanctioned and sought amount. These are all relating to 2011-2013, my lord.
So that is the main concern of the court, saying that is not a stale. No, the first thing is that whether it's not a stale claim, and whether if many things have happened in the intervening period from 13 till
only thing
now
is,
till
my lord,
21.
What has happened if
anyway, we do one thing. You file a short affidavit, and we'll hear it on the next on admission. We'll have admission hearing.
Yes, sir.
Hearing Dr. Saraf. We'll fix it for admission hearing.
Yes, sir.
We'll fix it for admission hearing. Yes,
only
Dr.
one
Mozika, anything to say?
One sentence, my lord. My learned friend is saying the stale claim. From 13 to 41 to 2021, the government of Meghalaya is writing letters to the government of India.
We'll fix it for admission hearing. I think after 3 weeks. Yes, heard Dr. A.K. Saraf, learned senior counsel, issue notice. Stop, Mr. Mr. Dr. N. Mozika is present. We have respondents number 1, 2, and 3. 1, 2, 3, and 4. No further notice called for. The remaining respondents are presented by the Learned Advocate General together with the Senior Government Advocate. As such, no further notice called for. List this matter after 3 weeks for admission hearing. Respondents to file their short replies in the meantime. In the meanwhile, list also.
Item number 4.
Please, Your Lordship.
Yes,
Lordship, before this honorable court with a limited prayer, my lord. Just for the demarcation of the Akang land in view of the letter issued by the.
Where is the great Mr.
Lordship, I appear from.
Oh, here he is. Yes.
Lordship, notice has to go, my lord. I am only appearing for 1 to 5, my lord. The respondents.
I'm just
6 to 9 only here.
Lordship.
No, 10 and 11, my lord. Because the dispute is between the two private parties, basically.
Lordship, just with a limited.
Yes.
Just with a limited prayer, my lord. Just for demarcation of the land, my lord.
No, what's the back issue?
Issue, my lord, is that the respondent, private respondent, the people of Narangri Akhing, my lord, they're actually encroaching upon the land of the petitioner. So a proceeding also under section 145 CRPC has been drawn against them, my lord, and it's still pending. So now the issue is, my lord, if there is a demarcation, my lord, then the entire proceeding
No,
also
why
ends, my lord.
didn't go for the revenue in charge?
They went, my lord. That is what
Where's the
I'm
order?
in view of the letter, my lord,
Where's the
which is at annexure 8, my lord, page
Where?
32.
Page 32.
Lordship. This letter was issued, my lord.
This is September 22, yes.
Lordship,
Read
this
it.
letter was issued, my lord. With reference to the subject cited above, you are hereby directed to proceed to Rongsakre and Narangre Akhang lands for demarcation in presence of the Nukmas of Rongsakre and Narangre.
Here for Rongsakre.
Yes, my lord.
And for Naragiri, it's
Private respondent, my lord. And submit the report within a month for further necessary steps.
what happened after that?
After that, nothing happened, my lord. Despite due diligence from the petitioner, my lord, they have not acted upon, my lord. That is my grievance.
Mr. Dev, why you not acted upon?
Lordship, I have to take
Forget about the
instruction.
foreign respondents. If there's an order by your own authority,
Lordship.
that's why the deputy CM for demarcation or for doing an inquiry, why is not done?
Yes, with that, my lord, I have to take instructions, my lord. At the moment, I don't have any instructions, my lord. So let notices be issued, my lord. I will come with instructions, lordship.
No, but he has another prayer that timber is being felled. Where's that?
Lordship. No,
Letter
but
before that.
I'm not against that, my lord. I'm only with a limited prayer, my lord, just for demarcation of the land, my lord.
Let them come for instructions first.
Lordship.
Why they're not doing it? I heard Mr. AG Moon and Consular Petitioner stop issue notice returnable in 3 weeks. Mr. S. Dev Vice SD accepts notice on behalf of respondents 1 to 5. MS S. Bharatachaji Learned GA for 6 to 9. Notices to issue to the respondents number 10, 11. Stop. Next paragraph. The limited prayer according to the counsel for the petitioners only against the inaction of the district council respondents in executing the demarcation which have been ordered by letter dated 19/9/2022 by the deputy chief executive member between Rongsakre and Naragiri Akhing. Stop. The next paragraph. The learned counsel for the respondents 1 to
5.
1 to 5, my lord.
1 to 5 are directed to obtain instructions positively before the next date. List accordingly on so and so.
Meanwhile, my lord, status quo may be maintained, my lord, because there's a miscase, my lord.
And next, where's the miscase? So.
Item number 5.
A miscase?
Miscase.
Miscase here.
Miscase.
Send.
Yes, next thing. Miscase of 26/2023. This is an application for maintenance status quo between Rongsakre Akhing and Naragiri Akhing pending disposal petition. Stop. Heard Mr. AG Moment on the interim prayer. Why do you want to think they are felling trees? Where's that?
Lordship.
It is submitted that status quo is necessary to be ordered due to the fact that there might be destruction of property. Where you see that? Where you see felling trees? There's nowhere.
Just to maintain breach and breach of peace, my lord.
Thomna? There might be there as a likelihood of breach of peace between the parties concerned. So, what do you have to say, Mr. Deb?
Lordship, we have to take instructions, my lord, because we are not aware of
next paragraph. Mr. S. Deb, however, submits that he is not aware of the situation on the ground and may take instructions. So, next paragraph. However, in the interest of justice, it is directed that till the next date, status quo is maintained in the boundary between the boundaries between the two actions. This accordingly also so along with this main case.
Hello, Blashman.
obliged, Lordship.
5.
Please, Lordship. This is second round of litigation, Your Lordship, where in the earlier...
Like a boxer, in a boxer, they fight 3 rounds. So PG Sama also goes 1 round, 2nd round, and 3rd round. So.
There was a defect because I don't want to just give up the case because there was a defect on my part in the pleading. That's why earlier we have withdrawn with the liberty to file this case. That's why we are again come. This issue, Your Lordship, what happened? These petitioners, they have been working for more than 30 years, 25 years. Now there is a scheme, Your Lordship is very much aware that regular casual
25 to 30 years.
1996, yes. They were appointed in the year of 1987, and from that now all the petitioners, they have completed more than at least some of them 27 to 30 years. Now there is a scheme because there is a regular casual worker where some benefit has to be granted to those regular casual workers. Since they have been working for more than 30 years minimum, and they are retired. Now at that time, of course, Lordship, they
were they appointed as casual ad hoc workers?
They were appointed as for the civil task force.
Civil task force is different from casual workers. Where is that?
Yes, Lordship, there is an act also.
So where's the appointments?
Appointment, Lordship, I did not enclose, but I just, because there no appointment, no official appointment was given. I have mentioned also. They were given only the ID card. And ID
if
card.
There's no appointment, you know what comes next?
It's
just disappointment.
No, other Lordship, other people who have earlier run on litigation, not people, they have already been disposed of. They have come before this court at that time, and there were some benefit were given to them, Lordship. That judgment also is there, but I'm not on the basis of that one. There is a page 36. May I take your Lordship? There is a judgment from this court only. There is an observation, Lordship, page 36, where it says that whatever the case may be, since they have been working for the last 25 years continuously without any break, I think it is that they are entitled for the benefit of the wages under the scheme quoted above. Government should consider their grievances sympathetically and give them the wages under the said schemes. There is at least a petitioner have some, this is similar people who have got this benefit, Your Lordship.
Where similar people, they who came by with elected petition, they all got benefit. What benefit did they get?
They of course, during the filing of the case, they have settled the matter and they got it.
What benefit? If you're asking for a similar benefit, and you should know benefit they got.
This Lordship, that scheme, Lordship, may I take you to the page 29, 30. There is a scheme is from the type copy, page 29. Office memorandum, where it says dated 16 September 1996. There is a scheme, Your Lordship, office memorandum. Then the continuous of this.
What do you want to show the court?
Here, Lordship, there's
the benefit.
Then page 30, that paragraph 4 is.
All right. Yes.
There said that an RCW shall be entitled to earn leave on probate basis at the rate of 1 day or for every 14 day spent on work.
What do you mean 14 days? It's for every. Who typed this?
I think it's a typing mistake, but
yes.
And second also is that
15 days become 14 days.
15 years. Sorry, I will correct it because my colleague they type it. Maybe I also
never blame your colleague. You are the person who's standing before the court. Every mistake that's made by any junior or colleague, anything, it rests on your shoulders.
Yes, Lordship.
And you take full responsibility.
Yes, Lordship.
Yes.
Yeah, I may be allowed to.
They are under your guidance. No, doesn't matter.
This is only typical for mistake. The second, RCWs are also entitled to leave of absence up to the maximum of 15 days in a year, but no wages shall be admissible.
No. Why are you showing this scheme? Have they been put under the scheme to other people? After it came to court, other similarly situated people like you, they were absorbed under the RCW scheme.
Yes, in this scheme only.
Where is that? Just show that.
That way, but only I put it in the order. But at the time,
order says consider sympathetically. Okay, it ends there. It does not give any direction that you put them under the scheme or whether they're entitled or not. It just says that on consideration the fact that it's a very general order that they've served for 25 to 30 years. So you go back to the government we will consider your case sympathetically. Those were other, not your clients, the other people.
Yes.
So there was sympathetic consideration, and you say they were given the benefit of RCW scheme. Is that correct?
Yes. On the,
Is that correct, Mr. Barasaji?
Yes. Yes, Lordship.
No.
They have, if that.
Then where do you stand then? If that's not correct, they were not given this scheme. Why playing this scheme?
See, in the order, in that earlier order, they have reflected, your Lordship, that RCW on the page 34. The basis of the order. Page 34. Page
34 is the order again. This is the quotation or synopsis of whoever filed a case that time. It's not an order.
This is not order.
Suppose the earlier judge, whoever sat for convenience sake.
But on the basis of this only, that order, their observation has been made of.
Just a sympathetically. Okay, this is one paragraph order. What happened after that? What kind of sympathetic consideration did they receive? What benefits did they receive?
They got one times payment, Lordship.
Oh, then say that.
Yes.
Is that correct?
One time payment. Earlier round, my lord, my friend, the petitioner has approached this honorable court on the ground that, my lord, that matter had travelled till Supreme Court. Now, my lord, Supreme Court had said that, okay, that was a case, my lord, where the government had asked them to, my lord, retire. It was a scheme of voluntary retirement, my lord. Now, when the question came, voluntary retirement, this question came, my lord, then thereafter, my lord, because against this order, the government approached the Honorable Supreme Court. Now, during the pendency of the case, my lord, there was a settlement was arrived at, and in the settlement, it was decided that one-time payment will
there's another case dealing with that also.
Yes, that is the case, my lord. So earlier round, my lord, petitioner approached this honorable on that ground that since they have got to give us the benefit, so now in the second round, now he has come with the RCW.
So you want that settlement should apply in rem to you also.
Yes.
Correct?
No, see.
But you have not annexed anything, no appointment order or nothing.
And most important,
even those people also, they don't have.
Most important,
this list is there in that, along with the order,
the petitioners.
Yeah.
My lord,
page 30, their lists are there.
Case was settled, my lord. In that case, the petitioners were in service. But, my lord, here the petitioners on the first round also approached after retirement. Now in the second round also after retirement.
Yes, this court remembers now.
Yes. So after retirement again he is coming that you please give us RCW status.
But the nature of the work is the same. They are also carrying it as per the Civil Task Force Act.
Forget about the scale of the work. You have not been able to establish the manner of the appointment, the nature of the duties, and where exactly they serve. Nothing is there. Just saying that I serve for 25, 30 years that will not, clothe you with any right.
They have given only the page 30, the list of these people, how they have given the appointment. That is just give like that by the department only. So the 30 it is the list of those people who are appointed. This is the manner they have given. And moreover,
the date of retirement, my lord. This question had arisen because during the course of the hearing, my lord, the clarification was required. So this clarification was produced, my lord. That these are the periods.
That page?
It is at page 38. Because we stated that all the petitioners have already retired. So
yes.
Of course, we are admitting they have been retired. They are retired. But at least the fact is that they have worked for 25 years. We are not asking for regular pension. We are only asking since there is a scheme where it's supposed to be implemented on.
You know something? There's a saying. Beating a dead horse to try to make it run. Horse has died, you're trying to make it carry your burden. How will it do?
No, one can be one thing you lordship can appreciate. The similar matter I have repeatedly.
Similar matter does not cover your case.
It's not covering, but they are the same people who do is same nature of appointment, same the work.
No, Mr. Sangma, it was on a total different basis. They were in service as GE submitted. Number two, they were in service. Number to come for this court, there was an order to consider sympathetically. They had gone up to the Supreme Court, and while it was there, then they worked out because they were still in service. Some kind of settlement was worked out. They given one-time settlement, and they all left the service. Correct?
Yes.
And your case is that you were there in service before that, right? Then you retired. Now, one fine day after your retirement, you retired around 10 years ago. You found that those people who were working similar, they received some money. So an idea clicked, just go and go to court and get the same order.
No, actually,
and
what
it didn't
happened?
work out the first round, now second round. I think that's the case, right?
No, Lordship. Actually, what happened officially?
They thrown out appointment orders also. But that 10 years ago.
It is unofficial. Of course, what I was instructed actually. They were together with all this at the time of service only.
Exactly.
But due to maybe I don't want to mention other, don't want to blame also. But as per the instruction of this petitioner, they went together and then at the time of service only they have been filing this one. But due to some reason, I think whom they have engaged anybody, I don't want to mention, but they don't put their names. And then later on, along with that order, they went to the court and court. The director says you also have to bring that type of order. Then they said, why you didn't pay? They said, actually, they were together. But I did not mention it unofficially.
In the other case, only two petitioners.
Only two petitioners, but 50% were given, granted PNP. They were only two petitioners, but 50% were, those 50% were not even come to the court.
Case?
Lordship.
It will not yield anything.
Lordship, at least we will, admission hearing, I will bring some judgment. At that, if not Lordship, I will just veto it, but give me an opportunity. I will just try to place some judgment on this.
What judgment will you place on this?
Lordship, I have, but at this stage I didn't bring Lordship.
So what judgment can you bring? You have only that it will apply in REM.
I'm not Lordship. I just for the interest of justice. Last chance given, then later on, if court not satisfied, I will not force also. But I will just try to place those judgment. Lordship.
Do one thing. You bring the earlier judgment regarding this matter. Yes, heard Mr. P.T. Salma. This is matter after 3 weeks for admission. Mr. Kibi is present. No further notice. No notice called. NRGA is to produce the earlier judgments on which the petitioners are seeking to take shelter in.
Yes.
For grant of similar benefit.
Lordship.
Right. But remember the dead end street, huh?
Will any affidavit be required?
No.
Lordship.
Yes, that's it. So have a nice, I won't be around for maybe 3 weeks or something. So yes.
Safe journey.
Much obliged, Lordship.
Yes.